Alrighty, so we're just at the hour here. Why don't we get started? We got a lot to talk about today. My name is Joseph Caniglio, and I'm the Director of Antitrust Innovation Policy and the Schumpeter Project on Competition Policy here at the Information Technology Innovation Foundation. On behalf of ITIF, I want to welcome you all to this great panel we've got for you, FTC v. Meta, the end of antitrust populism. As brief background, the FTC v. Meta case represents a long-running antitrust saga of a case first brought by the Trump administration, first Trump administration, who had its initial complaint dismissed. Complaint was refiled and survived under the Biden administration, and then litigated ultimately by the second Trump administration, who just about a month ago was handed really a shellacking, to put it mildly, by Judge Boasberg here in the DC District Court. The FTC's basic theory was that Meta's over a decade-old acquisitions of the photo sharing app Instagram and messaging service WhatsApp maintain an alleged monopoly in a personal social networking services market, which was defined to include only four competitors: Facebook, Instagram, Snapchat, and MeWe. In a really landmark opinion, Judge Boasberg ruled against the FTC by finding that Facebook did not have social media monopoly power, without even having to address whether its acquisitions of Instagram and WhatsApp were actually any competitive. As he explained, not only did the direct evidence and indirect economic evidence make clear that Facebook competed with TikTok and YouTube, but even the qualitative analysis of market definition upon which the FTC relied failed to demonstrate Meta's monopoly power. So to discuss the FTC v. Meta case and the decision and its implications, I'm fortunate to have with me a really great group of experts. So first, Jess Malusian, Director of the Center for Technology and Innovation at the Competitive Enterprise Institute, as well as an Antitrust and Competition Policy Fellow at the Innovators Network. Jessica's research covers a broad range of technology policy issues, including antitrust, privacy, AI, telecom, communications regulation. Frankly, I don't know how she does it all. And she writes and speaks and cited widely in leading publications like New York Times, Wall Street Journal, Washington Post, and many more. Jess, a real pleasure to have you back with us. Thank you.
It's my pleasure. Thank you.
Second, Alden Abbott, Senior Research Fellow at the Mercatus Center at George Mason University School of Law and an advisory board member at the Antitrust Education Project. Alden has had a distinguished career in government, to say the least, from 2018 to 2021, serving as general counsel of the Federal Trade Commission, where he had previously worked in a number of senior roles in prior administrations. Alden also spent many years at the Department of Commerce, including as acting general counsel, and additionally as special counsel at the Antitrust Division during the Reagan and Bush 1 administrations. Alden's also held high-level positions at BlackBerry and the Heritage Foundation, and again speaks and writes and is published widely on all varieties of antitrust issues. So good to have you back with us, Alden. Thank you. Third, Brendan Benedict, principal at the Benedict Law Group, where he represents clients in complex antitrust and commercial litigation. And he's been recognized as a top plaintiffs litigator and a next generation leader in law by LogDragon, as well as other publications. He's participated in several high profile antitrust cases, including representing the state of Utah against Google, as well as Qualcomm in its win against the FTC. He regularly writes, speaks, and is quoted on antitrust and tech matters. And I know many of us have been reading his commentary on this case over the months. So Brendan, thanks very much for taking the time.
Great to be back with you.
Okay, finally, last but not least, Dan Gilman, Senior Scholar of Competition Policy at the International Center for Law and Economics, where he researches and writes broadly on antitrust, economics, and competition policy issues. Before joining ICLE, Dan was an attorney advisor in the FTC's Office of Policy Planning, and before that taught law and econ at the University of Maryland, Penn State, and WashU in St. Louis. For those of us who know antitrust well, Dan is a prolific commentator, and he's got his regular blogs over at Truth in the Market that are really must-reads for all of us in the antitrust policy world. So Dan, welcome.
Thanks, Joe.
Great. So let's get started here. We've just got so much to talk about. And Alden, maybe you might kick us off if you would. So, this opinion obviously was focused on the question of whether Meta had monopoly power. And we really had a very rigorous, I think, opinion from Judge Boasberg, and really going through the different categories of evidence that you would analyze if you're determining whether a company has monopoly power, sort of starting with the most probative, I think, to the least probative. And the most probative, sort of where he began, was this question of direct evidence of whether Meta had monopoly power. And there were a number of arguments that the FTC put forward here but none of which I think he found very convincing. So maybe we might just start there. What are your thoughts on the monopoly power issue with respect to some of the direct evidence that the FTC put forward, and why Judge Boasberg rejected it?
Right. Well, there are a number of points. I mean, he just goes by all of the FTC's arguments and uh, demonstrates, and I think pretty conclusively, their flaws. Let's start. He made his profits were, and supposedly anti-competitively high profits. He said, look, that's first of all superior technology or return of investments could have accounted for those profits. None of those possibilities rebutted by the FTC. The FTC also failed to present any evidence made as profits were abnormal compared to other high profit industries, a necessary component of proving monopoly power. Now, the consumer sentiment, for example, Judge Boasberg rejected the argument that made reduced quality through by saying that, look, the FTC failed to prove the company held a monopoly, and that made it plainly invested to improve its services, not degrade them. Ad load, supposedly the burden of advertising, feature improvements, investments in ad quality, and dynamic market competition meant overall there was no quality diminution. User sentiment surveys were unreliable evidence because they did not reflect the fact, they just reflected broader brand perceptions and not the fact that Meta's products were improving. So it was a continuous improvement of Meta's products over time, despite the FTC's claims of quality degradation. It was a dynamic and competitive market. And TikTok and YouTube were strong rivals. Unreliable user sentiment surveys, I think I already mentioned that. Court concluded also that an increase in ad load did not mean a decrease in quality when Meta was simultaneously investing in making ads more relevant and engaging. And the court rejected, also argued that Meta's ability to show more ads to say certain users was merely a form of price discrimination. Happens in businesses all the time. Not just a possible indicator of market power, but not necessarily monopoly power. Now, as to the evidence, so this is sort of the direct case. I think we're going to hit the indirect evidence later. Is that right, Joe?
Yes.
Okay. Do you want me to? Should you submit somebody else directly?
Yeah, no, I think that was a great overview of some of the key direct evidence, Alden. We're going to dig into the indirect case, but usually the direct evidence, if it's available, is the most probative. So Dan, I want to turn it over to you here next on the direct evidence before we get to some of the other stuff. I mean, some of these arguments about profitability leading to monopoly, or as an evidence of monopoly power. You have the question of the ads and then price discrimination. I mean, some of it I just thought was sort of shaky economics, right? I mean, you can price discriminate even if you're not a monopolist, and you can be a monopolist who can't price discriminate, right? So what do you take on the direct evidence point?
Well, I think Alden's right. I mean, the direct evidence wasn't very sound, and of course, if you're talking about things like profits or related measures like markups over cost, these can be relatively poor proxies for either for vigorous competition or for a lack of competition. You can have increased efficiency, and there are all sorts of problems with this. I mean, to follow up on Alden's point about the quality evidence, I think it's maybe worth mentioning that yes, antitrust is concerned with non-price dimensions of competition, including product quality. That's a legitimate consideration, and it's one that has come up in various cases. At the same time, it's difficult to mount a product quality only case, and for very good reasons, and maybe that's highlighted here. I mean, we can talk about changes in ad quality versus ad load themselves, we can mention that, it's pretty easy to scroll through ads on Facebook or Instagram in a way that one might not be able to do in other settings on other platforms. But I think, the more basic issue is that if you choose sort of one qualitative aspect among many, and there was quite a bit of evidence, in the pleadings and at trial, that there were many other qualitative issues at play, right? Both at the time of acquisition and since and ongoing. There have been introduction of new features. There's been feature refinement. There are many, many features here that different consumers can appreciate, and so, right, you can pick on one dimension out of many qualitative dimensions, but it's sort of like saying, well, Toyota has reduced the number of paint choices that don't get some sort of markup if you're choosing a Camry, and so the quality of Camrys is worse. Well, it might be worse, but there's rather a lot more going on, and it's sort of tough to hang that argument on choice in paint color alone. So it's hard to make a quality-driven argument with multi-dimensional products like this. It should be hard to make it, and I think even just the focus on ad load to the exclusion of other things was a mistake. I mean, they looked to the mistake because they couldn't point to, if we're talking about end consumers, people on the platform, you can't talk about an increase in price. You can't talk about an output reduction, even if Facebook loses market share to actual competitors that were left out of the FTC's market definition, right? There's no systematic output reduction, and so all right. So you try to tell a qualitative story or focus on markups, which may be an economic distraction, and it doesn't work. It just doesn't fly.
Thank you. I think that's the key point. The FTC really had to strain here because sort of the typical indicia of direct evidence price output were just not in its favor, clearly. But Brendan, turning it over to you, we talked about the quality point on the ad load and consumer sentiment. I think Dan, had it right. It was really hard for Judge Boasberg to sort of make clear that what direction some of that evidence pointed. How do you see this issue?
Well, he didn't have that issue when he was considering one of the FTC's kind of backup arguments on quality, which was that Meta was underinvesting in its core use case of friends and family sharing. That really became the focus as trial went on, sort of narrowing from personal social networking generally to a use case that's focused on seeing updates from your friends and sharing things with them. And he called the idea that Meta would underinvest in that, economically nonsensical, basically. That Meta would have an incentive if it were able to charge something akin to a monopoly price by increasing the amount of time the users spend on the platform. And if the reason that users want to be on the platform is for friends and family sharing, then it doesn't help Meta maximize profits to decrease the time that they spend there by underinvesting in that, because that means if there's less time spent on the platform, there's less advertising revenue that Meta can earn from monetizing that time and attention. But the FTC, had some evidence of that. One example that we heard about at trial was a new Friends feed, which I'm one of the few Luddites that maybe only uses Facebook on the desktop. But if you go on the mobile app, and it's available just on the mobile app, there's a button that you can push at the top that gives you a version of your news feed that just updates from friends and family. There's no ads in that feed. And that's something that Chief Judge Boasberg came back to a couple times because the data showed that not a lot of users were actually using that feed, which sort of cut against the FTC's theory that was, in fact, the core use case. Now, I think that was a little uncharitable because Meta only rolled that feed out like 6 weeks before trial. So it's kind of a litigation-driven decision, I think. And Chief Judge Boasberg, didn't really discount the fact that there wasn't big public awareness of that. I think one thing that's interesting that's happened since the trial has ended is that Meta has now launched a new marketing campaign doubling down on friends and family, maybe showing that investment that the FTC said it didn't do in the past. There was a campaign around the time of Thanksgiving this year that showed users, going back to their small town for Thanksgiving and connecting with friends over the app. So it's a little bit frustrating and maybe jaundiced to kind of take the evidence that develops on the 5-yard line before trial as proof that the FTC, couldn't show a reduction in quality. And that's what I think, was maybe the most striking thing about this opinion. Maybe we'll get into it later, but Chief Judge Boasberg did it in a way that was, really ruling against the FTC on evidentiary issues that are difficult to appeal, making credibility determinations and determinations about weighing the evidence rather than, sort of getting past the monopoly power hurdle and deciding the fact on anti-competitive effects where the law is a little more unsettled. So it was an interesting choice, and I think it's one that makes an appeal difficult here.
Brendan, thank you. And I do want to get into some of those evidentiary issues because I agree, but just maybe finishing off on the direct evidence point and maybe Jess turning it over to you on this investment question. I mean, I think one of the things Judge Boasberg found, and I think was supported by the evidence, is that one of the reasons maybe investment fell in the friends and family was that the users that market had sort of matured, so to speak, and the market was evolving. And clearly, more generally, Meta was still investing in these products, right? I mean, that was the point, I think, of a lot of just where the market was moving and how it was growing. But how do you see that question on maybe the investment issue and also more generally direct evidence?
Yeah, I mean, I agree with that specific point as well. I think that for whatever reason, most people, and there will be exceptions, of course, are just choosing, they're just posting less generally, and they're using it to watch entertainment more than they're using as a friends and family communication. And I think that points out kind of an important fact about the reality of this market is that there's other ways to share with your friends and family. You can text them, you can message them. Maybe that's where you want your photos. You don't want to show it to the whole world of Facebook. I think that Facebook and Meta and Instagram invest where they think consumers want to go. Which again comes back to a larger point of if they viewed TikTok as a competitor, it makes sense that they're moving away from that friends and family model, and they're trying to give their users what they want to keep their eyeballs on their platform. So, and the fact that the friends and family tab showed up at the last minute or showed up after, I mean, I think it's sort of naive to say that we're going to have the government attack these wildly successful companies and that they're not going to do anything. I have no idea what that decision that they made was influenced by. Maybe they really have information that people want that. We haven't seen much of that. Or maybe they're doing it, to look good. I don't know, but I don't also really blame them. If you wanted what their business decision was, we shouldn't have taken them to court for it. So to say that they're adjusting because they're under the existential threat of breakup before this decision came and that was disingenuous, I think, it is sort of a naive way of the way all businesses at that size have to operate in this environment that's been very, very hostile to tech. And and just more generally about the direct evidence, I mean, I think it just, the FTC just didn't make their case, right? There's just too much real evidence that we can see that this is not a monopoly. And obviously the relevant market definition was the intrinsic problem there.
Right. Well, thank you, Jess. And I mean, I want to turn now to the indirect case because, to be fair to the FTC, a lot of these monopolization cases are not won on direct evidence. Usually what happens is the FTC or the government defines a relevant market and then makes the indirect case. So let's turn to that now. And Dan, I want to start with you. So we have the market definition issue and the friends and family PSN market, which the FTC stuck to. When we talk about indirect evidence here, we're talking about really two categories. And I want to start first with the quantitative category, the really hardcore economic evidence, looking at things like natural experiments and some of the other things that Judge Boasberg considered of past conduct that sheds light on monopoly power. And, this case obviously comes in a backdrop of a lot of attack on the use of economics in the antitrust profession. And, one way to read this decision really is, for me, the revenge of the economists, given how important and how much weight Judge Boasberg put on these economic studies. But how do you see this part of the case?
Well, I think it's sort of an interesting part of the case, and I've been critical in print of sort of the main story that Scott Hemphill told and trying to make the indirect case. But I do think that he said some reasonable things, both positive things and negative things, sort of rebuttal things in talking about the economic evidence. If you want to look at any piece, any given experiment, I mean, it's really hard to see one of these as definitive. I think what you end up seeing is that as a whole, they all sort of point in one direction, right? So the natural experiments are imperfect, but that doesn't mean they don't show you anything. Where do people switch? Where's the substitution? I think moreover that the core of the FTC's market definition case wasn't technical at all, right? It was a sort of slicing and dicing of so-called practical indicia grabbed from the so-called brown shoe factors, and especially the sort of peculiar features and characteristics. And I think that this is something we all do at various stages in trying to, to put on enforcer shoes, trying to screen a merger, like where's the space of competition? What do we look at? But it's right. It's one thing you look at, but your intuitions can just be extraordinarily misleading about these things. And when you start to construct what looks to be a gerrymandered market definition, and a gerrymandered market, look, it's these features exploiting this particular kind of social graph, and no matter that consumers seem to be switching and morphing, and that the acquisitions in question, an interesting thing about the case is that the WhatsApp acquisition was in there, but it almost sort of dropped out of what the FTC was trying to argue. I think maybe that was a good thing for the FTC, because it was a really bad argument. But
all these years later, it's a competitor, but it's still not in the relevant market. I never understood that.
And it certainly wasn't at the time of acquisition. It just, and if you go back, some people have tried to argue, oh, you should have looked at this at under 2012, 2014 terms. What's the interest in taking this big risk for something that's so long ago consummated, where you don't have really good direct evidence of harm to competition and consumers? But be that as it may, there were many photo sharing apps when they acquired Instagram. They obviously wanted additional functionality. There were many messaging apps when they acquired WhatsApp. They wanted some additional functionality, a different platform. I get it, but this stuff just didn't fly. And to Brendan's point before, you sort of, well, right, maybe this Friends tab, as configured with the Friends feed, was new, but they have maintained all along functionality like, you could, with a few clicks, construct a private group of, just 5 of your friends and family, or 50, or 500. You could control access. You could have, through their platform, all sorts of functionality for communicating, sharing, viewing with some group of friends and family of your choosing. And I think, the real problem with that argument was that there were perfectly good competitive reasons for first Facebook, then corporate-wise Meta, to shift their investments. And the thing that didn't make economic sense was the idea that, they had this enormously popular platform in which they supposedly had market power. They noticed this smaller thing off to the side with, TikTok and these other platforms that that were not in the market, and they decided, you know what, let's trash our not just market power but monopoly power in this market and invest heavily in competing in this new and supposedly distinct market in which we're a newcomer and in which we're really going to have to fight for market share. I mean, look, maybe they wanted to compete in that market too, but if that was it, but it's this is the thing that didn't make sense, right? That they would, shoot themselves in the foot to fight an uphill battle someplace else when they could have max,
Right. Well, that's the key point, I think. I mean, we had this great evidence of switching, and one of the things the FTC said was, oh, it's the cellophane thing, right? They're a monopoly already. But then the key point was that there was not just they were switching; they were the closest competitors in some cases, even closer than some of the other firms in the market. But Brendan, turning it over to you now, I want to get your views on this, and as a litigator, maybe too. Just, I think the interesting point about Hemphill and how his testimony was treated by the court. I mean, many times you get these battles of the expert, right, where they basically cancel each other out. But here, that was definitely not the case.
Yeah, well, I think he had a tough job, and it was an uphill battle because, as we've indicated, the traditional tools of an economist in defining the market aren't available here. The consumer doesn't see a list price. So, there's not a price to observe, a price increase to observe over time. So there's really no way to do the hypothetical monopolist test except to do it in a qualitative manner. And that just feeds back into the arguments that Dan and others were discussing before, which is, there's many factors that go into quality. And so if your one sort of quantitative factor is ad load, but you don't deal with the quality of the ads themselves or with other quality features of the platform, like reducing spam, like the rollout of maybe games on Facebook.com, you're not sort of grappling with the platform as a whole. So it's easy for Chief Judge Boasberg to come back and find that, there's these other quality dimensions where quality is arguably improved. And so there's no way to weigh that. And that's really where I think they fell short. Now, I did think the FTC did a good job in poking holes in some of the quantitative evidence of substitution from the natural and field experiments. And a lot of that testimony was from Meta's expert, John List. The issue with those experiments is that, remember, when we're defining a market, we're trying to ask the question of, would a monopolist find it profitable? What's the smallest set of products over which a monopolist would find it profitable to impose a small but significant and non-transitory increase in price? So if your field experiments are transitory, or they're more than a small price increase, what that is going to do is define the market too broadly, and really take people's exit from the market as evidence of competition. So to take, one example or a couple of the examples were around blackouts of apps, the natural experiments, or bans. So there's a ban of TikTok in India, banned briefly in the United States. All the experts agreed that's not a small price increase. That's an infinite price increase. So of course you're going to overstate substitution from Meta's apps to TikTok and YouTube, if and back and forth, if some of those apps are just unavailable. I think it was the same way in some of the evidence about, blackouts from Meta's apps. Well, they went offline for a couple hours and usage on TikTok increased. Well, that's transitory. So we're not interested in that in answering the hypothetical monopolist test. But, I think the real issue there is in the battle of the experts. At least Meta had something quantitative to point to. Maybe it was flawed. And Chief Judge Boasberg, kind of gave lip service to these issues of, yes, I know it doesn't answer it's not a SNP type question, but it's something. And it's better to have some quantitative evidence than none. And I think that's where, Hemphill fell short. There was some other stuff going on there about accusations of bias for Scott, where he did this purported roadshow with Tim Wu to the FTC and state enforcers to try to encourage them to bring suit, and maybe made some, statements that weren't so careful in that because they didn't have access to the discovery record. But I think that was really just, something that demonstrated that, Scott sounded more like an attorney for the FTC just because the traditional tools of economics weren't available in this case.
Brendan, thank you. And I mean, that was almost one of the most interesting parts of the opinion was after hearing from the Neo-Brandeisians for all these years that antitrust enforcement had been too influenced by academic economists telling the agencies what to do. We sort of learned that the FTC case was started by Tim Wu and Hemphill coming in there and saying that they should bring a case, which is very interesting. But Alden, turning it over to you. I mean, I think Brendan really raised an important point about some of these experiments that Judge Boasberg really valued very highly, especially the field experiments by Meta's expert, Dr. List. And, there's been a lot of talk about the role of behavioral economics in antitrust and doing that sort of thing and some of the concerns there. So, was that a little bit, maybe too much emphasis on that as opposed to some of the other experiments? And how do you see the economic natural experiment and other observational evidence here?
Well, I think they sort of had to turn to these, to look at natural and field experiments because, look, we've already shown, I think they didn't really have much of a direct evidence case. But I think looking at, I think basically what Judge Boasberg said, look, you can argue about particular aspects, infinite price increase, as Benedict mentioned, if there's a shutdown or something. But if you look at a pricing experiment, Meta outrage, India's TikTok ban, TikTok pause in the US, and YouTube outage, a consistent story is when consumers cannot use Facebook and Instagram, they turn first to TikTok and YouTube. When they cannot use TikTok or YouTube, they turn first to Facebook and next to Facebook and Instagram. So he says, the judge says, that leaves no doubt that TikTok and YouTube compete with Meta's apps. Now, as I said, it's a limited number of experiments, but it is what it is. You don't, and one of I think the bigger question about behavioral law and economics is it doesn't necessarily prove anything. They say there are stories about how companies, for instance, some behavioral law and economic stories that companies aren't profit maximizing because consumers are not sensitive to changes in company behavior, and it basically it assumes said that the old story, simple story of rationality is not good to use. But the whole point was, I think Milton Friedman made it in his essay on positive economics. He said, look, the perfectly rational consumer, perfectly rational company, those are constructs. They're constructs to try and look at how the world operates. And we look at, the fact, of course, there are imperfections in every market. There are imperfections in consumer sentiment. But okay, if you say that, then you don't have an answer. You can, if you say there's irrationality by consumers, you can bring a case by saying whatever the companies did, they raised the price today, they lowered it yesterday, change their policies tomorrow, and irrational consumers who are used to dealing with this same company will just follow on. Well, it doesn't really now allow for an analytic approach to deciding whether or not to bring a case. So that, I think, is a big problem in general. And obviously, this case did not present all of those things. And I think it's partly in essence, saying there are imperfections proves too much. Of course, set aside the fact that the Austrians would say you don't really have market equilibria, you're constant seeking of opportunities in the market by transactors. But I think the reason you don't see nearly as much behavioral economics in the courts as it was imagined 15 years ago is precisely because it's very hard to handle. Warts and all, the hypothetical monopolist case here was, the weight of ads, of cluttering ads as being a price increase. Warts and all, it at least is something you can turn to. And you can also, but behavioral law and economics is not really something that's very good at uh, deciding how to decide a case or what case to bring.
Alden, thank you. I mean, we talked about Milton Friedman and the Austrians, and I just had a blog come out about some of the philosophical dimensions to this case, which I think are there, but I don't want to take us down that road just yet. Jess, maybe you could round us out first on the evidence here. What do you think that was most compelling to Judge Boasberg when he was looking at these experiments?
Well, I think he was influenced by those natural field experiments, and I agree with Brendan; they're not perfect, and but I do think that, beyond not being the perfect examples of how we've written things down to be, right, where it's transitory or it's this percentage or whatever, those are approximations, and we can be a little flexible about that, I think. But I think what's interesting, or what is compelling, and I think the judge found this too, is that the substitutions were consistent across all this, right? It wasn't like, well, one time when this went out, everyone went there. It was because it was so consistent of where people went when one or the other was out, and that the same four names were there. I think that it does raise a very reasonable point that, listen, TikTok and YouTube should be in this relevant market. And not to say that those experiments are perfect. They're certainly not. I agree. But I do think just the consistency of where people went when these things weren't available, even though it was temporary in some cases, is a compelling argument that this relevant market was ill-defined. And I also think about the cellophane fallacy stuff about saying, well, the fact that you didn't see a lot of people move off Meta platforms when there was, as the FTC claimed, degradations in privacy policy or things like that. I mean, first of all, it doesn't really matter in the first place, as the judge said. If this isn't a monopoly, that's not a question we need to ask. But also, one explanation is that indicates there's a monopoly. But another explanation is that consumers' revealed preference does not match up with what the FTC says their preferences are. And I think because you have a positive feedback of your ads improving in quality when they have more data on you, I think that's not a concept that's discussed enough. I mean, there are people who don't mind those ads at all. And as we said earlier, they're pretty easy to avoid when you do mind them, much easier than if you were watching more traditional kinds of media. So I think that there's an argument to be made that even degradations in privacy policy or a higher ad load, it's more nuanced than that, because what are you getting for that as a consumer? And also, is it improving the quality, and do you mind? I don't think is a given. I don't think it's like television advertising where it's like, oh my gosh, you're trying to watch this and it just has a million ads. They're much better ads. They're targeted to you. They're things you might want to see and buy. And I think that part of it gets left out of the conversation. Ads can't really be dealt with in bulk like we have in past industries. They're a much different creature.
Jess, thank you. So I want to go to our next topic, but before I do, I want to make sure I invite the audience to ask any questions they might have vis-a-vis Slido. I know there's a lot here, so please do send us your questions. I'd love to have some time to discuss them. But briefly, and then I want to really get into the implications, because I think there's a lot to talk about there. But maybe briefly, just everybody can maybe give a minute or so on the qualitative case. And look, to be fair to the FTC here, right, this is what they focused on. And not without good reason, in some sense, right? I mean, we know direct evidence can be hard. It's not always what makes these cases tick. And as Brendan pointed out, there really was no good way to do the HMT in this case, which is the typical quantitative analysis. So there was going to be some qualitative analysis here. Brendan, why don't I start with you? I mean, why didn't the FTC win even on this?
Well, I think that's because the nature of usage on Meta's apps has changed over time. And that's what the court found. So, the way I think about it, the FTC really focused on what are the, to use the language of the brown shoe, practical indicia, what are the peculiar uses or purposes or characteristics of the different apps. And it really hung its hat on purpose. You go to Facebook and Instagram to connect with friends and family. That's much different from why you go to LinkedIn or Twitter X or some other apps. And I think of that meme from a couple years ago with that Dolly Parton started, where there's 4 different pictures of you in quadrants, and you're wearing a different outfit depending on what app it is. In LinkedIn, you're wearing a suit, and Facebook, you're posing with your friends and family. And there's something intuitive about that. That people's behavior is shaped by social norms, and the FTC had an expert, Cliff Lampy, who this was his point, which is that people are using the apps for different things. Now, I think what Chief Judge Boasberg found was that the nature of usage has changed, and a lot of the survey evidence or academic literature that Lampy relied on was outdated by the time of trial in 2025. You see a lot more personal type posting on LinkedIn these days than you used to maybe back in 2012 or 2015 when some of these studies were from. And one thing that Chief Judge Boasberg keep coming back to was how much users on Facebook in particular don't post anymore. People rarely post to the news feed, and the overwhelming amount of time spent as a percentage of time spent on Facebook and Instagram has become consuming unconnected content, in particular short form video. Now, even there, I think this is another example of a jaundiced evidentiary take that is a little uncharitable to what the FTC showed and is difficult to challenge on appeal. So to take one statistic, the court kept coming back to stats showing that Facebook users spend only 17% of their time today on friends and family content. So if the overwhelming majority of time spent on the platform isn't what the FTC says the core use case is, doesn't that mean then that Facebook is disciplined by competition from other short form video platforms? But what the FTC showed was that while the percentage of time has changed, the absolute time spent on friends and family hasn't changed. And what that means is just people are spending more time overall on Meta's apps. The overwhelming majority of the new time that they're spending is going to short form video content, but it didn't take away that core amount of time spent on trying to connect with friends and family. So I think that's what the court found. To do that, it had to blow past, the FTC's kind of rebuttal of that point. And you see that, throughout the opinion. Another aspect of this that's changed is that a lot of the usage is now private. Maybe that's because we all got sick of each other after the 2016 election and the news feed is toxic. But Chief Judge Boasberg also came back to the idea that users are really using the private messaging features on the platforms. I'll, confirm my own anecdotal experiences. There's a lot of sharing of memes and group chats on Instagram these days, sharing of the reels. So a lot of connection is still there. It's just not happening in the same broadcast sharing format. That's what the FTC was really talking about with friends and family sharing through their expert Cliff Lampy, and that's what's, I think, different today.
Brenda, thank you. Jess, turning it over to you. How do you sort of get the sense on sort of the qualitative analysis? And I mean, I think there is one point in response to what Brendan said, which I think the FTC had a lot of time still figuring out, that friends and family sharing could occur on platforms that were not in the market too, right? I mean, I think that was certainly also an issue, right? Even within the friends and family definition. But please, your take.
Yeah, I mean, I think Brendan's exactly right. So much of this has to do with the passage of time since this was started, and that's kind of just a built-in difficulty for the FTC here, and it makes it easier to kind of contrast what was happening at the beginning with what the numbers are. And you do see some of that, which probably doesn't paint the FTC's arguments in the best light. Although it's just when things take 5 years, it's, I think, to some extent unavoidable. And you probably see that in a lot of different brown shoe factors, that maybe this was a particular, sub-market use at the time. But the problem is it's certainly not now. And you have people multi-homing and doing a lot of these same things on different platforms and a different mix of that. And like Brenda was saying, private messaging to share more. And all those things have been evolving. And I think probably if you look at the industry recognition of things, has evolved as well. You can probably find lots of quotes from earlier on that suggest maybe this was more of a distinct thing, but that's probably not the case once Meta became very concerned about TikTok eating its lunch. And I think that probably goes the same for, distinct customers, and that we're all learning to use these apps however we want to use them in these different blurred categories don't hold up very well in practical use. I think that's just the way it's gone. I think also it kind of goes to the point that these are not unique facilities. If they've all begun to kind of morph into each other's services and offer the same things, I think that's a real blow for, it's not the same as a steel factory being able to turn out aluminum cans. So I just, and as the judge said, it just, the FTC didn't deliver on this.
Exactly right. And the sort of unique facilities point is interesting because I know the reels was really important part there. And I mean, Judge Boasberg found like that was Meta responding to competition from TikTok, right? And just showing the sort of supply substitution there. But Dan, I almost feel bad asking an economist to talk about qualitative evidence like this. So maybe another way we can take it is, this time horizon point, right? I mean, was there a case for the FTC to say, well, Meta had a monopoly before, they don't have it again, but they're still within the statute of limitations? And I mean, is that what they should have done rather than trying to say they had a monopoly today?
No, I mean, and I'm flattered, but I'm not here as an expert economic witness, and my degrees are in other things, sometimes related. I think, look, I'll get to your question very quickly, but I mean, to one of Brendan's points, and I mean, I say this as someone who spent 16 years at the FTC. I know the FTC has brought a lot of good cases. I think they still can and do bring good cases, but the stuff about jaundiced and uncharitable, it's not the job of the judge to be charitable to the plaintiff. It is the plaintiff's burden to make the case, and they didn't make the case. Sorry, you want me to focus on?
Well, no, I mean, we're in an open discussion now, but that's helpful.
I think that's the bottom line, and I think the fact is, should statute of limitations? Let's compare and contrast with something like the Northwestern hospital case, which was a post-consummated merger case where the FTC was successful. They were right to bring that case. It was right that they prevailed in that case. You had, you look a couple years post-merger, you have solid direct evidence of harm to competition and consumers. The law does allow the FTC to go back and look at these mergers. I mean, here you had this very swimmy, Section 2 pattern and practice of anti-competitive. These two acquisitions were part of this practice, which wasn't shored up with much else. I think, let's turn it on its head. This is an enforcement agency with limited resources. And, this was always a multifaceted product or service. This was true 5 years ago, 6 years ago. It's true 2 years ago. It's true when, the FTC finally got an amended complaint, second amended complaint over the line. These are multifaceted things. And I think that the sort of, the slicing and dicing just didn't wash, right? Either at the time of the acquisitions or at the time they went to trial. I mean, what was the incentive to risk all these resources over all of these years if they couldn't make the case in the way the judge said they should have, namely present or imminent ongoing threat to competition and consumers? You say like, oh, look, in 2015 or in 2020, we could have won this case. We could have had a good argument. Well, I mean, they made the argument in court when they got to court. And it seemed to me that they were fighting uphill. I mean, I know what people were talking about in 2012 and 2014, and people in the building didn't think there was a case here. I don't think I'm revealing any non-public information and saying that they were right.
They did bring a challenge. Absolutely. So Alden, turning it over to you now. I want to get your final thoughts on the market definition issue, but also, Dan raised this point about just the agency's resources and how much time is spent on this case and whether it was strategic. I mean, one thing we've heard in some of the commentary is that this might have been different if they brought it as a Section 7 case rather than a Section 2 case. Do you have any thoughts on that? I mean, did they just drop the ball? In under Section 7, they wouldn't have had to even show monopoly power. How do you see it?
Well, I don't think that really would have worked, actually, because look, WhatsApp and Instagram were arguably providing new services that were complementary to the social networking that Facebook was doing. It was not the idea that one of those two companies would have become a major. You would have had to show afterwards, in a but-for world, one of those companies would have become a superior competitor of Facebook. You would have had welfare enhancement, so even better product results, and it would have been direct competition to Facebook. But you couldn't show in a but-for world at Facebook that things would have been better. There was no real evidence for that, because what you know is that Facebook improved the quality of Instagram and WhatsApp offerings. It improved the quality of its actions on its platforms. Economic evidence of the welfare benefits bestowed by platforms indicate that those benefits rose as those improvements gained. So again, the idea that there's all studies of consumer welfare gains by Professor Brynjolfsson at MIT and Stanford, one should look at what he's written. But the bottom line is that where was the harm to consumer welfare? We know that consumer welfare rose. The argument would have had to be, well, it would have gone up at an even higher rate and even higher. But there's no requirement to show that a merger is going to prevent a maximum amount of consumer welfare. The merger, there's no real credible showing that consumers were harmed. I think, and the consumer welfare was reduced. So I don't think that would have worked. And even though there's no latches applicable to government, I think bringing a Section 7 case, people would have said, was there really any harm? Weren't lots of people benefiting from the growth of Snapchat? As a practical matter, it is a bargain that, if you decide not to bring a Section 7 case, many years later, with scant evidence, it looks troublesome if government's trying to have a second crack. Most of the consummated merger cases, some of them were smaller cases that flew under the radar, mergers to monopoly. The hospital case, Northwestern, was a merger to monopoly. It was clear, direct evidence of substantial price increase, not a good evidence of quality improvement. So again, those few cases, you had really strong evidence. Here, there was no strong evidence. So for all of those reasons, I don't think Section 7 theory stands up.
Absolutely. I think that's exactly right. As hard as it was for the FTC to show monopoly power, the hardest thing was to show that the consumers would have been better off had these transactions not occurred. And Section 2 maybe gave them the lower causation burden to try and do that, which is why they went with it. But anyway, so we're nearly finished here. We got about 5 minutes left. But I do want to ask everybody to just sort of give maybe a quick concluding thought on the question, sort of the title of our panel, the end of antitrust populism, because we're not getting a breakup in Google search. We're not getting a breakup in Meta. We'll see what happens with ad tech, but I think any breakup there would sort of be separate from a lot of Google's the search business, for example. Amazon and Apple, I don't even think the FTC is. Well, they're not asking for a breakup in Apple. They left it on the table in their Amazon complaint, but they're certainly not going to get it there. So is this case really the end of the populist breakup big tech movement for all intents and purposes? Jess, why don't you start us off?
Yeah, that's a great question. And I'll give an unsatisfying answer. I don't know. On one hand, there's been a little bit of a cooling of the excitement on this front, right? I think part of the Biden administration, a real desire to test these theories in court, and they've gotten some pushback on that recently. So maybe the enthusiasm for that has cooled. On the other hand, we still have plenty of enthusiastic, populist, tech-hating leaders in antitrust right now at agencies. So I don't know. I'm going to hedge my bets and say we could see one more. Is that, I don't know what the over-under on that is, but I don't think it's completely over. And we see that, as you mentioned, there are other cases that are ongoing. I don't know that they'll be the dream populist results, but I don't think this conversation is over.
Jess, that's of course the right answer because we all work in tech policy and do this. So you got it.
Yes, we've got mouths to feed.
Alden, your take on the big picture issue.
Okay, look, unfortunately, I don't think it's over. I mean, Judge Boasberg, a very sound opinion, although he was a history major. It's a really good opinion on applied economics. I think the kind of opinion that Frank Easterbrook could have written, for example, and nobody would have been surprised. So it's a solid opinion, but there are different theories in the other different cases. Even though there's no breakup, seemingly, of some Google assets we'll see in ad tech, that's imposed enormous, the case has already imposed enormous costs on investment potentially in improving your systems, including auctions. Facebook is still out there, and looking big picture, the administration is fighting hard against anti-competitive foreign regulation. There is a hearing today before House Antitrust Subcommittee, and witnesses testifying about the harm of anti-competitive regulation, Digital Market Act, other acts overseas directed at the American platforms. It really undermines the ability for the United States to go overseas and say, you're unfairly attacking our platforms when you're bringing cases that, frankly, I think the current Supreme Court, if you were to pluck out all of the remaining platform cases, monopolization cases, it's not going to happen, but the Supreme Court majority would give it thumbs down. Yes. And I think that it's really counterproductive for the administration to bring these very theoretical cases based on dubious stories of consumer welfare if they want these because it undermines leverage in international negotiations about regulation. And I think it would be great if the administration would step back and rethink this whole set of cases.
Alden, thank you. Dan, your take.
Oh, from your lips, Joe, to no, but look, I think I wouldn't over-index on any given district court decision. We got a lot of district court judges, and you know, are we going to see, you know, populist sentiments driving cases on the public side or private side going forward? You know, probably what's going to weigh in a given trial with a given judge, I don't know. I think Judge Boasberg, look, as I said, you know, in terms of economic evidence, none of it was perfect, but the weight of the evidence was not on the FTC side, and sort of on the practical evidence, I thought the weight of the evidence wasn't on the FTC side. So I thought this was a good, smart, generalist judge wrestling in a practical sense with, you know, precedent and the evidence before him. I don't know that these broader movements are over, and honestly, I think, you know, we want to focus as somebody who doesn't really identify with either or any of the many populist movements floating about. I'd rather look at the merits of an individual case, right? What's the economic evidence? Economic evidence, broadly speaking, if we have good, you know, if we have really good, tight evidence, that's great. You know, market studies, all kinds of evidence brought to bear. And yes, you know, there's judgment and there's soft evidence as well. But, you know, I think we need to go case by case. And, you know, my case against the populist line is that it's really overbroad and oversoft, right? I mean, it's not that Meta or any other tech platform is wholly impure and can't violate the antitrust laws or any other law. I don't know how to make that argument. It's let's look at the case that's before it. Let's look at the conduct at issue, the transaction at issue. And here I thought the FTC was on weak ground, and they rightly lost. What's going to happen tomorrow in another matter? We'll see. I do like the fact that this judge, like Judge Mehta in the Google search case at the remedies phase, is looking at dynamic aspects of competition in a space where there clearly are dynamic considerations. What's the model for doing that exactly the right way next time? I don't know. But I like the fact that both of these district court judges in the District of DC focused on these aspects.
Yeah, even so, we got a couple quotes from Heraclitus about a changing world here. That was a real treat for us. So
I will leave the Heraclitus expertise to you, Joe.
Read my article. But Dan, this is disappointing because I was hoping you'd be the resident populist here. So I guess we're going to have to turn to Brandon and conclude. Brandon, what's the hope for the Neo-Brandeisians here? Give them some hope after this shellacking from Judge.
Yeah, but populism is dead. Long live populism. Look, Joe, you said that this was the strongest case, and the poll of the experts that I think Dan's group did, everybody agreed this was the weakest one. Amazon is still to come. Apple's still to come. Remedies in Google Ad Tech. It's just the beginning. And I think antitrust populism has permeated the public consciousness in a way that we've never seen before. Lena Khan and Jonathan Cantor are on TV and podcasts all the time making these arguments. There's a new sorry, Dan corrects me that Amazon polled even worse. Well, this is just one of four, right?
Best case for a breakup. That best case for a breakup. I think that's probably true, though.
Yeah, and in any event, the point is that this is now, a new movement, and there's a new generation of law students and economists and scholars who are paying attention to this in a way that nobody had, certainly not when I went to law school more than a decade ago. And I think this particular case was just, some litigation choices, some decisions not to challenge it at the time. I'm going to disagree with Dan. He says nobody at the FTC thought it was a problem in 2012. What did the evidence show from the time before the lawyers got to them, before the economists got in the room? Mark Zuckerberg said the reason for the acquisition was to neutralize a potential competitor. That's what the case is about, and that is what antitrust populism is about. It is looking at what are the companies saying and doing. There's lots of a million experiments we can do, but it's hard to undo what comes out of the mouth of babes, and that's what this case was really about. It's unfortunate we didn't get to the part about anti-competitive effects, but I think there's a lot of cases coming in the future, and this movement has real bipartisan legs, and be on the lookout for it.
Brendan, thank you. I think we'll have to end it there. It's good news for all of us who do antitrust policy, which means there'll be more panels and tweets and articles to come. But I want to thank everybody for what I thought was really an outstanding panel here. We're so fortunate to have really the top experts discussing these issues. I want to thank everybody who tuned in. This is you just heard it. These issues are not going away in one form or another, and we're going to continue to keep covering the tech and antitrust stuff very closely here at ITIF. So sorry to keep everybody a little over, and thanks for a great panel. Have a good day.